Assalamualaikum and hi everyone. This is the another topic on the industrial design law. Okay, this is another type of IP. We have learned about the copyright, we have learned about the trademark, we have learned about the patent. So now we are moving to the new types of IP, which is industrial design law. Okay, so what is this law is all about? Okay, the purpose of the ID, okay, industrial designs or also ID, is to protect the appearance of articles. So meaning to say that the purpose of ID is actually to protect the appearance of the article, not how you come up with the article. For example, here I have mouse here. So the purpose of ID is the design of this mouse. Okay, the design of this mouse, not how you come up with this mouse. Okay, so that is the purpose of ID. Okay, and then which are commercially mass produced. Okay, it must be commercially mass produced by granting the owner of the registered design the exclusive right to use the design. So we have to go back to the basics of IP, in which IP, the purpose of protecting any types of IP is actually for the innovator or for the owner to gain any profit from it. Okay, so if you protect an IP but you did not gain any profit from it, so it shouldn't be protected under IP. For example, um for example, if you have if you have photocopied a books, okay, a textbook. Okay, photocopying a textbook for the purpose of research or for the purpose of education serve as a defense under section 13 of the copyright. Why? Because you did not get any profit from it. Okay, so if you photocopy a book, okay, can the writer or the author of the book sue you for the infringement? No, they can do so lah. Why? Because you photocopy the book for the purpose of education. Okay, you did not gain any profit. Right. And this ID serve to differentiate the article from other articles in the marketplace which can perform the same task. Okay, the usage of the work here refer to the article. Article here doesn't mean journal article. Article here means that the product itself. Okay, for the apa orang kata, for the copyright, we refer them as work. For the trademark, we refer the product as a sign or a brand. For the patent, we refer them as innovation. Okay, jadi thus for the ID, we refer the product, the IP as the articles. Articles is actually the product itself. Okay, so we will learn on what is the definitions of ID, what is the requirement for the work to be granted as ID, who own the ownership of ID, how do you deal with ID, the infringement defenses and revocation of ID. And the governing law for the industrial design is Industrial Design Act 1996 as well as its regulation. Okay, Industrial Design Act 1996 dan dia punya regulation. So term of protection for the ID is for a period of 5 years from the date of filing. Okay, 5 years from the date of filing, and you may renew it for 4 consecutive years. Meaning, the term of protection for the ID is actually 25 years, but you have to renew it every 5 years. Okay. Alright, so this is the requirement for a work to be protected under ID. Okay, before we go to the requirement, let us take a look at the introduction. ID is actually any features of shape, configuration, pattern or ornament applied to an article by any industrial process which must be appealed to and adjudged by the eye. Just like I mentioned just now, okay, the concept of ID is actually on the we are actually judging the appearance of that particular article or appearance of that particular product. So that is why the finished article must appeal to and are judged by the eye itself. Okay, so in the case of F&N Diaries Malaysia and Tropicana products, okay, the Court of Appeal noted that the definitions, there are two aspects of definitions in the definitions of ID. First, there is positive aspect and there is negative aspect, and these two aspects must be satisfied. Okay, there are positive aspect and negative aspect, in which these two aspects must be satisfied in order for that particular work to be protected under ID. Okay, so later we will take a look what is the positive aspect and negative aspect of the ID. So the registrable requirement for ID, there are three registrable requirement. First, it must meet the meaning of industrial design under section 3, and then it must be novel under section 12 subsection 2, and it must not be contrary to public order and morality. So the requirement, all these three requirements must be met in order for that particular work to be protected under ID. Okay, meet the definitions of ID. Second, it must be new, and third, it must not be contrary to public order or morality. If one of these requirement is not satisfied, then that particular article cannot be protected under ID. Okay, first, let us take a look at the definitions of industrial design. Okay, just like I mentioned just now, in the case of F&N Diaries and Tropicana products, the court mentions that there are two aspects of the ID that must be fulfilled, the positive and negative aspect. So section 3 subsection 1 define ID as any features of shape, configuration, pattern or ornament applied to an article by any industrial process which can be appealed to and adjudged by the eye. Okay, this one is the positive aspect. Okay, so this is the positive aspect. Okay, but it does not include method or principle of or construction or features of shape which are detected solely by the function and are dependent upon the appearance of another article, and this is the negative aspect. Okay, negative aspect. Right. So from this definition under section 3, we know that there are two aspects of the ID, two aspects on positive and negative aspect of the definitions of the ID itself. Okay, first, it must be a features of shape or configuration applied to an article by any industrial process and can be appealed to and adjudged by the eye. So that one is the positive aspect. But at the same time, okay, even though this positive aspect has been satisfied, but if the idea actually involve method or principle of construction, or it features actually dictated solely by the function or dependent upon the appearance of another article, still it cannot be protected under ID. So that's why in the case of F&N Diaries, court held that these two aspects, the positive and negative aspect, must be satisfied in order for that particular invention, in order for that particular articles to be protected under ID. Okay, so let's take a look at the definition one by one. Okay, first is the features of shape, configuration, pattern or ornament. Okay, in the case of Castos and Campite, okay, courts held that ID must be either in 2D or 3D. Okay, 2D or 3D. It must be in 2D or 3D, or you can combine this 2D and 3D. For instance, okay, a vase is made in a certain shape. Okay, so when you make this vase in a certain shape, so it fulfills the 2D definition. And when you decorated a flower on the surface of this vase, then it is considered as through 3D. So this is actually the combination of 2D and 3D, right? Okay, next is it must be applied by any industrial process. Okay, what does it mean by applied by any industrial process? Okay, for example here, a spoon must have a basic shape in order to perform the function assigned to it. Okay, a spoon must have a basic shape in order to be up to perform the function assigned to ordinary spoon. Okay, so this basic shape cannot be the subject matter of an ID. Why? Because it has no industrial process. It has not been applied by any industrial process. Okay, so how do you know that there is an application of industrial process or not? Okay, when you actually modify the fundamental shape. Okay, you modify the fundamental shape by let's say making a handle in the shape of a seahorse would added a new shape to the spoon. Okay, so this newly added shape, that's what we call as the industrial process. Okay, for example, we have the scissor here. Okay, we have the scissor here. So the design of the scissor, why is it like this? Because it wants to perform its function as a scissor lah. Okay, so kenapa design dia macam ni? So that it can perform its function as scissor, right? So can this be protected under ID? No, it cannot. Okay, no, it cannot because it doesn't have any industrial process. Okay, how do you know that there is industrial process or not towards this scissor? You add a new shape to this. Okay, you add a new shape to this, then the newly added shape to, that's what we call as the industrial design. Okay, we also may refer to the case of Siti Khadijah and Ariani Textiles, where what they want to protect is the telekung itself. Okay, the telekung untuk solat lah, which is a Muslim prayer outfit. Okay, so the issue was whether can this be protected under ID? Is this considered as industrial design or not? In which court said no, there is no industrial design towards the telekung. Yelah, what other shapes can you add to a telekung? Of course, there is no other shape other than what we are wearing like today lah. Okay, third is the article. Okay, section 3 subsection 1 define article as any article of manufacture or handicraft and includes any part of such article or handicraft if that part is made and sold separately. So what is article? Article means any articles, any things that you manufacture, any things that you that is handicrafted. So that is what we call as article. In the case as Littlewood's Pools Limited application, the court held that an article in the context of ID must have some purpose other than that merely of carrying the design. Okay, let's say lah. Okay, let's say this, I have this pen here. Okay, I have this pen here. You put this design here just for the sake of carrying the design. There is no other purpose of this pen, of this design here. Okay, no other purpose. So can this be protected under ID according to the case of Littlewood Pools Limited application? No, it cannot be protected under ID. Okay, because it should have any other purpose other than that merely carrying a design. For example, a drawing, a painting. Okay, those things, can it be protected under ID? No, it cannot, because drawing and painting normally we will protect it under copyright. Okay, the fourth element is it must be appealed to and adjudged by DI. Okay, ini yang keempat from the definition itself. So DI appeal must be present in the finished article. It is DI alone that judges the aspect. Okay, so there must be an I appeal. If there is no I appeal, then that particular articles cannot be protected under ID. But does this mean that the finished product must have an aesthetic value? It must have be aesthetic merit? Okay, no, it's not like that. Okay, it's not like that. This does not mean that the finished article must possess aesthetic merit. Because why? Because this is subjective consideration. Beauty is in the eyes of the beholder. So it doesn't mean that that particular work or that particular articles must have an aesthetic value. Even though yes, we do judge it by the eye, but it doesn't mean that it has to be of high aesthetic value. Okay, to some people the features may be such as to gain their favor, while to others it may receive a negative response. Okay, cantik dekat A tak semestinya cantik dekat B, but still for the ID it must be appealed to and adjudged by the eye. So why? Because we are actually looking at the appearance of that particular product. Okay, we are looking at the appearance of that particular articles, not on how you come out with the article, not how you invented the article. Okay, kalau kita tengok on the process of invention, that one is actually protected under the patent. Okay, the process on how you come up with a product. Okay, that's why under the patent, one of the requirement for a work to be patented, it must have inventive steps, but there is no such things as in ID, because in ID we are only looking at the outer appearance of the product. Okay, we may take a look at the case of F&N Diaries and Tropicana product. Okay, please pay attention to this case because this is actually a landmark case with regards to this ID lah. Okay, alright. So what happened in this case is that one of the issues discussed is whether the product, okay, the juice bottle. This is actually a juice bottle between F&N and Tropicana. Later I'll show you the design of the bottle. Okay, so the issue in this case is that whether the design of the bottle is actually appeal to the eye of the customer. Okay, so who is the customer in this case? Okay, the customer. Okay, now we are talking about appeal to and be judged by the eye. So appeal to and judged by the eye of siapa? Of who? It is the eye of the customer. Okay, so in the case of F&N Diaries, they are actually try to determine who is the right customer for the F&N and Tropicana products. Okay, so in the F&N case, the design was the shape or configuration applied to a juice bottles. Okay, so the issue was who is the customer in that product. The customer court held that the right customer would be the person in the business of manufacturing beverages or juice and not the person who bought that particular juice. Macam kita lah, okay, we are the purchaser, we are not the manufacturer. So are we who is the right customer, the manufacturer or the person who bought the juices at the dekat Shell ke, dekat Speedmart ke? Okay, so the court held that the right customer, the right customer would be the person in the business of manufacturing. Why? Because they are actually when they brought the juice bottles, they are looking at whether these bottles actually serve whatever they want to. Macam kita, kalau kita tengok when we brought any juices, okay, be it F&N or Tropicana, we didn't take a look at the design of the bottle itself. So the one who take a look at the design of the bottle is the person in the business of manufacturing beverages. Okay, so the right customer will be the manufacturer, should be lah. Okay, but okay, F&N Diaries, in order to say that they are actually their design of the bottle actually has appeal to and judged by the eye. Okay, so they bring the purchaser as the witness in the court. Okay, the consumer itself, macam kita lah. Okay, the consumer sebagai as the witness in the court. So the court held that the witnesses were not the relevant customer because F&N should have brought the manufacturer, not the purchaser, not the consumer itself. Okay, so that's why court held that F&N has failed to establish the eye appeal element in this case. Okay, right. So those are the positive elements of the definition under section 3. Okay, now we are moving to the exclusions. So these are the negative elements ataupun negative aspect. So there are 3 aspects. First is the method or principle of construction. Okay, second ialah features of shape dictated solely by the function, and third ialah the features dependent upon the appearance of another article. Right. So first is on the method or principle of construction. Okay, a process of operation by which a shape is produced, not the shape itself. Okay, it's not the way you are actually trying to protect the on how you come up with the shape. Okay, macam mouse ni. Okay, macam mouse ni, what you want to protect is how you come up with this mouse, not the shape itself. So can the steps be protected under ID? No, it cannot. Okay, in the case of Phillips and Harbro rubber, court held that a registered design is something that is protected in respect of its appearance. Okay, we have to go back to the basic principles of ID. That is, it is actually protecting the outer appearance. Kita judge dia punya outer appearance. So if we allow the method or principle of construction to be protected under ID, how are we going to judge this appearance? So that's why it cannot be protected under ID. Okay, so it is for this reason that all attempts to make registered design cover modes of manufacture have rightly failed, and that the courts have so invariably insisted on the principles that the design must be judged by the eye alone. So that's why in the case of Phillips and Harbro rubber, court insisted that ID, we are actually under ID, we are actually protecting the appearance. So that's why any attempt to protect the method or to protect the process cannot be protected under ID. Right, so that is the first exclusion. Second exclusion is where the features of shape are dictated solely by the function. Okay, dictated solely by the function. Maksudnya, why the design of, okay, so let's say lah, so why the design of this, why the design of this scissor ni like this? Because it did, okay, because it want to perform its function as a scissor. Okay, kalau satu je macam mana nak jadi scissor? Okay, so that's why this one cannot be protected under ID because the design, why is it like this? Because it dictated solely by its function. Okay, or the design of this pen. Okay, the design of this pen. Okay, kenapa dia ada macam ni dekat bawah ni? Kenapa dia ada muncul ni apa semua? Because it want to dictate its function. Tapi dia ada dia punya extra function here, belakang ni. So perhaps this actually can be protected under ID. Alright. Okay, we may take a look at the case of an diaries again. Okay, so this is the juice bottles in question. Every feature of the shape and configuration of the plaintiff design was solely brought about by or attributable to the function which the bottle had to perform, namely to strengthen the bottle so that it could withstand the hot fill bottling processes. So in this case, other than the court held that the bottle doesn't have any eye appeal, could also held that, okay, the bottle of F&N here, okay, F&N bottle, actually, why is it designed as such? Because to strengthen the bottle so that it can withstand the hot fill bottling process. So it is to perform its function. Okay, function sahaja. Design dia macam ni untuk perform dia punya function. So that's why it still cannot be protected under ID. Okay, next is dependent upon the appearance of another article. So you cannot protect any ID if its existence actually dependent upon the appearance of another article. Okay, this exclusion is particularly important when considering when spare parts should be excluded from protection. Okay, for example, this bumper here kan. Okay, bumper here, it relies on the another article. Another article refer to the car itself lah. Okay, so kalau lah you nak protect the bumper itself sahaja je, still it cannot be protected under ID. Okay, why? Because its existence, the existence of the bumper to have its purpose, to have for us to judge the appearance of the bumper is only, we can only judge it, okay, ataupun it only has the purpose when it is attached to the car. Okay, so the appearance of the articles dependent upon appearance of another article. That's why it still cannot be protected under ID. Okay, this actually has been stressed on by the court in the case of Veresdale Limited and Dorwin Limited. Issue in the case was whether the hood, front bumper, rear bumper, and grille for automobiles, okay, is registrable or not under industrial design, in which court held that no, it cannot be excluded. It cannot be protected under ID. It falls under the exclusion under section 3 subsection 1 paragraph B2. Okay. Alright. Okay, so the next elements is the elements of novelty. There are 5 requirements for a work to be considered as novel. First, it must be new. Then second, you have to take into account the totality of the design. It must be judged by the eye, as always. Okay, priority date to determine novelty and scope of prior art. Okay, so first one is the design must be new. Right, even if the design meets the definitions of ID under section 3 just now, okay, it has fulfilled the positive aspect, it has fulfilled the negative aspect, but still it must be new. The design must be new. How do we know this? This is actually be provided under section 12 subsection 2. An ID shall not be considered to be new if before the priority date, okay, if before the priority date of that application there is an ID was disclosed to the public anywhere in Asia or elsewhere, or was the subject matter of another application. So if you have already disclosed the invention first, okay, the article, second, it is actually subject matter of another application, then it's not new anymore. Okay, this is be provided under section 12 subsection 2. In the case of Angkoso Sdn Bhd and Nehemiah reinforced Sdn Bhd. Okay, the court held that even where the prior art was not identical to the design, but it wouldn't be novel, okay, but still wouldn't be considered as novel if the differences between the prior art and the current article is so immaterial, is in immaterial details. So we need to say that if the differences between the prior art and the product, okay, and the current product is in immaterial details, so it's still not considered as new. For example, okay, there is this watch here, right? So the prior art, let's say the prior art has this button here, right, in my right hand side, okay. So the new article, okay, the new product, and it also has this kind of design here at the back of the watch, right? So the new articles that wanted to be protected under ID is, let's say he move this button here to the left hand side and there is no design at the back of the watch. Okay, can this be protected under ID? If we refer to the case of Angkoso Sdn Bhd and Nehemiah, no, it still cannot be protected under ID because the differences between the prior art and the prior art here, this current watch is the prior art, and the articles that they want to protect is only in immaterial details. Okay, so that's why it still cannot be protected under ID. It's not new. Right, second is the totality of the design to be taken into account. Okay, so you have to take into account the totality of the design. Okay, the totality of the design macam okay, macam this button here, camera dekat belakang ni apa semua. So the totality of the design has to be taken into account. Okay. So in the case of CKE Marketing Sdn Bhd and Virtual Sentry Sdn Bhd, okay, defendant has registered a design for a glass door display chiller. Okay, this is the picture here. Okay, the glass door display chiller in a refrigeration system. Plaintiff mentions that okay, this the registration, they wanted to expunge the registration, meaning they wanted to remove the registration on the ground that there has been a public disclosure. Okay, macam mana, how do the plaintiff claim that there is a public disclosure? Let's say this is the product. So plaintiff have separates the parts of the product and claim that this design has been there is a prior art according to the design that the plaintiff has already separated. Okay, the court held that in determining whether the novelty exists, the totality of the design must be taken into account, and the overall appearance of the article was an important consideration. So court held that plaintiff, you cannot separate these parts into several parts and then you claim that each of these parts has actually be disclosed to the public. No, in order for you to say that this particular articles has already been disclosed, okay, there is a prior art according to this, so you have to take into account the totality of the design, the totality of this design. Is there prior art or not? Okay, right. Okay, that is the case of CKE Marketing. Okay, third is judged by the eye. Okay, whether novelty exists in the task of the eye of the judge, guided when necessary by the instructed eye of the designer. So the eye of the designer here, perhaps we may refer it as POTA, as if in pattern. Okay, why? Because they are the person who play an important role. They know what amounts to common trait of knowledge and usage. Of course, even though that the task of judging the articles, the appearance of the articles is on the judge, but still, of course, judge tak tahu semua lah. So judge need to rely on the expert witnesses. So the instructed eye of a designer here refer to the expert witnesses. Right, priority date to determine novelty. This is actually be provided under section 17, subsection 1. Okay. So the priority date of an application for the registration is the filing date of the application, and therefore novelty is determined as at the date of the application. So we have to take a look at who filed first. Okay, who filed first. How do we know what is the date of the filing? The day you go to file your application dekat MyPo. Okay, so that is the date of the filing, and the novelty will be determined based on the filing date. Okay, the novelty will be determined based on the filing date. Okay, fifth is the scope of prior art. So an article is not considered as new if section 12 subsection 2 paragraph A there has been disclosure, and paragraph B before the priority date it's only difference in immaterial details. Okay, in the case of Teh Boy and Chua Siak Lu, plaintiff had obtained a UK design registration for its tool, but the validity of the registration was challenged by the defendant because defendant held that, and defendant mentions that they have actually manufactured the same design for 5 years. Okay, they have manufactured and they have sold the design for 5 years before plaintiff filed for the registration. Okay, as this fight was successfully proved, the court held that the plaintiff design was not new at the date of the application for registration because there has been disclosure to the public. Okay, alright. The third element is contrary to public order or morality. So, if you want to protect a design, you must be not contrary to the public order or morality. This is actually be provided in section 13. Okay. The idea that are contrary to public order or morality shall not be registrable. Okay, if your design is actually contradicts with public order, or it can incite religious hatred, or it is indecent or cause blasphemy or immoral, so the design cannot be protected under ID. Okay, so this is the example here. Okay, right now